It's a great day to fix the subway. Thank you all for being here. I'm New York City Comptroller Brad Lander. Transit riders are the heart of New York's working class and the heart of our city's economy. Every day, over 3 million working people, including the majority of our hospitality workers, of our home health aides, of our retail workers, of our service workers, rely on our subways and buses to travel to work, to school, and to all the other destinations throughout New York City. Unfortunately, our transit system is not as world-class as our people. And we've seen that throughout this summer with subway riders stuck on sweaty platforms, not being able to get where they're going, with service failures. Sadly, we've seen many stations without elevators have their accessibility projects canceled. Even recently at a station where a rider died after cardiac arrest after going up 3 flights of stairs a couple of years ago. The failures of our mass transit system are more and more evident every single day. Our transit system is in desperate need of a dedicated funding stream to enable the MTA to invest in a modern signal system that'll make sure trains come on time, to pay for the installation of elevators to make those stations accessible for all New Yorkers, to extend the 2nd Avenue subway to East Harlem so that people who have lacked an accessible and convenient connection to get it, to implement the Interborough X project so that new generations of outer borough New Yorkers will have access to the subway system. And of course, it's also necessary to make the investments that keep that system in a state of good repair. At the same time, traffic right here in Manhattan's Central Business District has never been slower. Vehicles in Midtown now move at 4.5 miles an hour. You can walk faster than that. And what that means is that taxi drivers, that bus riders, that delivery workers lose over 100 hours per year stuck in traffic, and we all pay the costs of that lost productivity and congestion. Lo and behold, there's a public policy that helps address every single one of those problems, and the people right here and many others did the work over years to fight and win that policy, and that policy is congestion pricing. Congestion pricing will provide $15 billion to invest in modern signals so trains come on time, to invest in elevators and accessibility so New Yorkers with disabilities and also parents with strollers will be able to get to subways through convenient, modern, functional elevators, to invest in cleaner, faster buses, to invest in transit expansion like the 2nd Avenue subway and the Interborough X project. And at the same time, congestion pricing will reduce traffic, reduce congestion, speed up travel times, and clean our air. It really is a win-win-win, and that is why, after extensive debate and conversation in 2019, both houses of the legislature passed, and the then governor signed congestion pricing into law, making it the law of New York State. So, when Governor Hochul halted congestion pricing last night, she single-handedly deprived millions of subway and bus riders of that $15 billion of investment in trains that run on time, in accessible stations, in less congestion, in cleaner air. And at the same time, in addition to all of that, she violated several state laws which make congestion pricing and the goals it sets out the laws of the state of New York. And that's why, as we announced here a few weeks ago, my office, working together with advocates, convened a broad coalition of legal experts, of advocates, of potential plaintiffs, of folks who ride the subway every day, of people with disabilities, of people who rely on our subways and buses, to get together and start to explore all possible legal actions to ensure that congestion pricing is implemented in New York as required by law. And since that initial announcement, we have been convening a legal working group consisting of attorneys from law firms, some of whom you're going to hear in just a minute, nonprofit legal organizations with expertise in environmental, disability, and civil rights law, lawyers from advocacy organizations that represent potential plaintiffs, including writers groups, New Yorkers with disabilities, people with respiratory issues, and business and residents residing in Manhattan's Central Business District. And so today, we are pleased to stand here to announce the filing of 2 lawsuits challenging the governor's unlawful decision and insisting on the implementation of congestion pricing in New York City. We're announcing 2 lawsuits, and you're going to hear from both the plaintiffs and the lawyers bringing them both. The first, City Club of New York and et al. Versus Hochul, challenges Governor Hochul's authority to single-handedly block congestion pricing under the original 2019 statute, the MTA Reform and Traffic Mobility Act, passed by the legislature and signed by the then governor in 2019. The law firm Emery Celli is leading on that suit. And the City Club is the lead plaintiff. The City Club is an over century-old organization that has as its mission good government and good development in and throughout Manhattan, and you'll hear from them. And the second lawsuit, Writers Alliance versus Hochul, challenges the governor's decision on the basis. Let's hear it for that. All right, great. And actually, it's not just Writers Alliance, even though, the first name plaintiff gets the name in the lawsuit, but Writers Alliance, Sierra Club, and the New York City Environmental Justice Alliance are the plaintiffs in that lawsuit. That lawsuit challenges the governor's decision on the basis that it violates the Climate Leadership and Community Protection Act, also passed by the legislature and signed by the governor in 2019, as well as the right to clean air and a healthy environment, which is established in the New York State Constitution. And the environmental litigation nonprofit Earth Justice is the lawyer leading that effort. Let's hear it for them. There are 2 separate lawsuits with 2 separate claims, separate plaintiffs and lawyers, but they are both being filed today. Each of them makes clear unequivocally that the governor's halt of congestion pricing is in contradiction of New York state law, and if either suit is resolved in our favor, it would compel the implementation of congestion pricing, and that would deliver the transit improvements, the more frequent accessible subway system, the faster buses, the cleaner air, and the smoother traffic that every single New Yorker deserves. Let's hear it for all of that. Before I introduce the folks who are speaking today, because you're just going to hear from the plaintiffs and the attorneys and the public advocate, it's a much bigger coalition. The attorneys signed a joint defense agreement, which enabled sharing legal information, which is not always something that folks get together to do. Advocates and plaintiffs got together. It really is a coalition of people, all of whom share this goal of a better and more functioning mass transit system and the investments that we need, and who have really rolled up their sleeves. These are people who have been organizing the rallies, who have been talking to New Yorkers about why this matters. New Yorkers know why they need trains that come on time and new elevators and cleaner air. They don't all necessarily know how the dots are connected, what the laws are, what's required. So I just feel a lot of gratitude to this amazing coalition of both transit, environmental justice, affordable housing, disability rights, civil rights advocates, and a really first-rate legal coalition of some of the smartest legal minds in the city. saying, how do we hold New Yorkers to the law? Sorry, I'm just thanking them, so I'm happy to tell you about it. But the folks behind me have really done extraordinary work in recent weeks. We're proud to have convened the coalition and brought folks together to do it. And I want to give a big shout out to Sindhu Bharadwaj and Louise Young and Annie Levers in our office. What we are proud to play is a convening role, but so many people have done the work. And now you're going to get to meet a few of them. As I mentioned, that first suit, City Club of New York, is being, the lawyers for that are Emery Celli, one of the city's foremost and best litigation firms, and we're really lucky to have them as one of the legal anchors of the coalition and the lawyers on the lead lawsuit. And it is my delight to introduce Andy Celli to talk to you about it.
Good morning, and thank you, Controller Lander, for convening and organizing this amazing coalition of advocates, lawyers, community folks, and concerned New Yorkers, all here to support what the law of this state requires, the immediate implementation of congestion pricing in New York City. My name is Andrew Celli, and along with my partner, Richard Emery, and our colleagues at our law firm, I represent the City Club of New York, Christine Berthet, and Kathleen Treat, the petitioners in the case known as City Club versus Governor Hochul, which was filed this morning in New York Supreme Court here in Manhattan. This is a case about democracy. It's a case that asks the question whether an executive official is allowed to defy the law, to ignore the will of the legislature, and to upend decades of long process of policymaking simply because at the last minute she changed her mind and didn't like the outcome. The obvious answer to this question is no. Governor Hochul cannot defy the law. She is bound by it. Governor Hochul cannot ignore the will of the legislature. She must respect it. And Governor Hochul cannot subvert the outcome of a fair, open, transparent policymaking process that included all the people. She must accept that. And the law we're talking about here is the Traffic Mobility Act of 2019. It's kind of wonky sounding, but incredibly important. By its terms, this law requires that congestion pricing be implemented. The word it uses is shall, and it uses that word repeatedly throughout the legislation. And this is the law that gives the sole, exclusive, and unreviewable authority to make congestion pricing a reality to the Triborough Bridge and Tunnel Authority and to the MTA, not to the governor. So that's the law, and that's what it says, but here's what it doesn't say. It doesn't say that Governor Hochul is the official in charge of congestion pricing. She isn't. That's the TBTA. It doesn't say that Governor Hochul gets to decide when congestion pricing is to begin. She doesn't. That's the MTA. And it doesn't say that Governor Hochul's transportation commissioner, who we also sued, can stall congestion pricing indefinitely by the bureaucratic trick of simply refusing to sign her name on a routine document. She can't. The New York State Department of Transportation has no say in congestion pricing, and they have said that themselves in court. So our lawsuit is very simple. It asks the court to order Governor Hochul and her transportation commissioner to abide by the law or get out of the way. No, the law could not be more clear. Congestion pricing must happen to ease traffic congestion in central Manhattan, to revive and upgrade our mass transit system for all of us, and to save the environment for today and for tomorrow. No single official, not even a governor, can stand in its way. Thank you.
All right, thank you, Andrew Celli. Thank you, Richard Emery, and everyone at the firm. You've now heard from the attorneys bringing that first suit. Next, you're going to hear from the plaintiff, the lead plaintiff for that suit. The City Club of New York is a good government group that has been deeply involved in New York City's urban development for over 100 years, and that backed congestion pricing from the beginning. They'll also be joined in the lawsuit by residents who live within the Central Business District and who will join as plaintiffs in the case because they have an urgent interest in enforcing the state law and enjoying the benefits of congestion pricing. And it is my pleasure now to introduce the president of the City Club of New York, Leila Law-Gisico.
Thank you so much, Controller Lander. It's really exciting to be here and to advocate for sound policies. My name is Leila Law-Gisico. I'm the president of the City Club of New York. Over 100 years, the City Club has championed sound environmental policies. The indefinite postponement of congestion pricing poses a significant threat to our city's infrastructure and environment. Congestion pricing, as you know, is designed to reduce traffic and emissions, leading to improved air quality and a healthier environment for all New Yorkers. This is not just an enhancement, it is a lifeline. But moreover, this program is essential to secure the critical state and federal funding required for major public transit investments. The MTA's ability to modernize subway signals, purchase new buses, implement vital accessibility improvements hinges on the revenue generated by the program. Without this funding, our public transit system risks falling into disrepair. So, for example, the next phase of the Second Avenue subway relies in very large part on the implementation of the program. Why? Because the federal government has conditioned its grant for more than $3 billion for the Second Avenue subway project on New York's ability to demonstrate that the state can provide its own share of the funding. No congestion pricing, no proof that we have the funding, the feds cannot issue the grant. This is why it is so critical. Postponing congestion pricing threatens this crucial project and many others, and it exemplifies the domino effect that delaying this policy will have on our infrastructure. And listen, we're not going to get people off their cars unless we offer a reliable public transportation alternative. This transit system needs the program for these crucial capital investments. The City Club stands for sound urban and infrastructure policies. We always have. The organization was founded in 1892, and it has been the core of their mission. If we want New York to remain viable, practical, enjoyable, economically viable, we need to be able to move. We can't continue to choke on vehicular traffic, and we can't continue to disinvest from our public transportation systems. The City Club, as a plaintiff fighting in court for the implementation of this policy, understands the urgency of these investments. They cannot be deferred. Our region's future depends on making bold, forward-thinking decisions today. Thank you.
Thank you, Leila. Thank you, City Club. So that is the first of the two suits. The second, Riders Alliance, Sierra Club, and New York City Environmental Justice Alliance v. Hochul, focuses on the Climate Leadership and Community Protection Act. And you're going to hear from the senior attorney at Earth Justice, Dror Ladin. Earth Justice is a premier nonprofit public interest environmental law organization, and we're thrilled that they are taking the legal work for the second suit. Thank you.
Good morning. Last weekend, we broke the record for the hottest day on planet Earth in recorded history. The people of New York have decided, and their legislature has decided, and their governor signed a law, our law. It's called the Climate Leadership and Community Protection Act. And that's what it provides. It provides climate leadership, and it protects our communities. And what it does is it means that every official in state government, from the governor on down, needs to take account of whether their actions help get us towards our goal of reducing emissions or take us further from it. There's no question what the governor has just done. Her decision is absolutely at odds with the requirements of the Climate Leadership and Community Protection Act. There's an official state plan for implementing it, which calls for congestion pricing. There's an official environmental assessment that explains what congestion pricing accomplishes. And what it does is it gives us a planet that we can live on, that our kids can live on, a planet without greenhouse gases at the levels at which they're coming out of the tailpipes of the cars here every day. This lawsuit brings claims that require the governor to actually follow the law, the Climate Leadership and Community Protection Act, and there are also claims under the New York Constitution, because in addition to the laws that the legislature enact, the people of New York recently amended our Constitution to say we have a right to clean air, we have a right to a healthful environment. And all the cars here that are putting out pollution that is causing asthma, that is causing COPD, that is making it hard for children, older adults, almost anyone to breathe, it needs to stop. It needs to be reduced. It needs to be livable. And at the same time, we need a transit system that works. So 3 organizations whose members live all throughout the city, in every borough, thousands and thousands of New Yorkers. Riders Alliance, which represents the riders, like almost everyone here today. Sierra Club, which represents people who have cared about the environment for decades, and the New York New York City Environmental Justice Alliance. Thank you.
Thank you so much, Dror. Thank you, Earth Justice. As you heard, that's got 3 lead plaintiffs. You're going to hear from one of them, Riders Alliance, which is only founded about a decade ago, has done a fantastic job representing the interests of strap hangers and transit riders, who, of course, are millions of New Yorkers who need the subway system, but before that weren't effectively organized and represented to demand what that transit system requires. So we're lucky and grateful that the Riders Alliance was created, and delighted to hear from its executive director, Betsy Plum.
Thank you. Good morning. Again, I'm Betsy Plum, Executive Director of Riders Alliance. We are New York's grassroots organization of bus and subway riders. Today, we are also proud plaintiffs defending the interests of millions of hardworking transit riders from Governor Kathy Hochul's unlawful last-minute decision. In 2019, we won congestion pricing because thousands of bus and subway riders united. It wasn't broken signals or door issues that lobbied Albany or pushed the governor to act. It was riders and our coalition, the collective power that we had to win a plan and the funding to finally fix our transit system. Now we have to use that power again to hold our leaders accountable. At Riders Alliance, we are not typically a litigious organization. Our work happens on the streets. It happens on subway platforms, at community meetings, at public hearings. We canvass, we rally, we organize riders. But today, our mission compels us in a new way to hold our leaders accountable to the democratic process that is fundamental to our way of life here in New York City and far beyond. Governor Hochul may dislike congestion pricing. She may fail to grasp the threats of climate change or our need for a reliable, accessible transit system. But congestion pricing, the Green Amendment, and the Climate Leadership and Community Protection Act are still the law. No matter what a small set of wealthy, influential special interests might tell her at the expense of millions of hard-working New Yorkers. Democracy, after all, Madam Governor, is for the many and not for the few. And so not to get too Civics 101, this is why we have checks and balances. Faith in our leaders, especially our governor, has been lost. And so we're now turning to the courts, our judicial branch, to show that democracy can prevail against unilateral, dangerous, and unlawful decisions by the executive. We will persist in our fight for a just, equitable, sustainable transit system. We will not stop organizing, but along the way, we will ensure that our leaders honor their commitments and the laws that protect all of us. Thank you.
Thank you, Betsy. Thank you, Riders Alliance. Thank you, Sierra Club. Thank you, New York City Environmental Justice Alliance. We've got a lot of other groups here. I'm going to shout some of them out as well. Thank you, Tri-State Transportation Campaign. Thank you, Reinvent Albany. Thank you, Open New York. And let's see, who else? What other organizations? Oh, TA is here. Elizabeth, thank you. Transportation Alternatives. And actually, a lot of the people that have been fighting this fight for a long time, too. So I do want to say thank you, Elizabeth Adams. Thank you, John Orcutt. Thank you, Rachel Faust. A lot of the people here who have been leading this effort for many, many years. It was an extensive and powerful coalition that did the organizing work to get the legislature to pass both of these laws in the first place and the then governor to sign them. That reflected the will of the people and a lot of hard organizing work in the public interest. And that is why these folks are going into court to make sure those laws are implemented as the legislature and the then governor intended. We have one more speaker to close us out. The public advocate of the city of New York, Jumaane Williams, is also a strong part of this coalition. As many of you know, last week he, along with the Transit Workers Union, filed what's essentially a companion lawsuit. It is party to the same legal defense agreement. It does not centrally challenge the governor's halt on congestion pricing. It challenges cuts to bus service that need to be restored, but it was part of the same legal defense agreement, and we are delighted to have the public advocate here with us.
Peace and blessing, love and light, everyone. Thank you for being here. Thank you to the Comptroller and all of the advocates and everyone who was here. As I've stated before, congestion pricing is necessary for the city and is needed to make improvements throughout New York. I have been a longtime supporter of congestion pricing, which I was always seen as common sense and a good method to benefit New Yorkers. The city was starting to quickly see the negative effects of cost-cutting measures undertaken by the MTA since the last-minute pause of congestion pricing. This includes many cessations, such as a pause on crucial elevator installations at New York City subway stations. So I'm glad the Comptroller and others in this coalition are taking legal action to hold the governor to legal and moral mandates. I've also, as mentioned, filed a lawsuit with the Transit Workers Union of America, Local 100, when there were cuts made to the bus services in several boroughs. This was also due to the indefinite pause of congestion pricing. The cuts made to the buses affected numerous transit riders and disabled commuters, making it more difficult for them to reach their destination safely and on time. Due to the lawsuit I filed with MTA and after a hearing, I'm happy that right now there was an injunction and the services have been restored. Today, that's good. Today, as we continue to challenge the indefinite hold on congestion pricing announced by Governor Hochul, I join Comptroller Lander and lawyers and plaintiffs and others who also agree that congestion pricing needs to go into effect to provide more accessibility to transportation, to elevators, improvements, and to operations within and throughout the city. Congestion pricing needs to be implemented so that New Yorkers won't be deprived of subways and buses that they need. And I want to say, this was a very, very long process. Decades in the making, if you want to be honest, and multiple years of making sure the final bill was passed into law. There was, I will admit, significant things that have happened in the world from 2019 until now. However, nothing significant happened between the time the governor last supported it internationally, saying how great it would be when we get it done, and 2 weeks later when she said we're not doing it anymore. There was no new information, nothing new had happened. And I'm also going to be honest, like I come from a family of drivers, and I understand it is important, but that cannot be on the backs of the masses of people who mostly travel with mass transit. We have to make sure that public transportation is paramount. And I understand everybody wants things to change. They sometimes just don't want it to change, particularly if it affects them. We cannot complain about the traffic. We cannot complain that our transit system needs money. We cannot complain about how bad our climate is with the hottest day on record and say we have to change it, and then say we can't change it. We just cannot do that. Now, I agree, and I will say that it wasn't, no plan is perfect, but I don't see a time ever that is going to be perfect to implement this plan. There's going to be, whenever we do it, someone complaining. The best thing to do is get it started, and we tinker as we go along. We'll fix it as we need to. But in order for that to happen, we just have to get it started. We have to have the political will to get it started. We actually had the political will. We followed every process. We went through every legal thing that was put in front. So to have the governor try to unilaterally stop this is not okay after every process was followed, and we're lifting up the vast majority of people who travel to the city, who are low income, who are working, who will not pay any kind of extra fare to get to and from the city for work, to be stopped by unilateral one person who we believe doesn't even have the legal authority to do it. So I want to say thank you so much for getting this done. And on behalf of most people who travel in this city, we got to win this one. Thank you so much. Peace.
Thank you, Public Advocate. Let's see, I neglected two thank yous. First, the person I've worked with maybe the longest on some of these environmental issues is Eric Goldstein from Natural Resources Defense Council. And also, last time we were here, we stood with Michael Gerard, who's a law professor at Columbia, who's out of town today. And while he is not one of the filing attorneys on these two lead suits, has been the chair of the legal advisory and working group and an essential part of this coalition. And we're very grateful to Mike Gerard in absentia today. Yeah, one more time. Let's hear it one more time for this great coalition, for the fact that we promised that these lawsuits would get filed and that they are filed, and for the better mass transit system that all New Yorkers deserve and that we will have when congestion pricing is implemented and those investments go into place. And now we'll be very happy to answer your questions. So the Comptroller's Office is not a plaintiff in either of these suits. The lawyers have worked to find plaintiffs with clear standing, and City Club, Riders Alliance, Sierra Club, and New York City Environmental Justice Alliance do, so we're not a party to either of these. There is research still underway on several other potential claims, including accessibility and civil rights issues, so there's still some research, and there may well be a suit there. There's some research underway on potential amicus briefs, and the lawyers are having conversations with potential filers there. We still do not anticipate the Comptroller's Office being a plaintiff on any of the forthcoming lawsuits. We're, pleased to have been able to play this coordinating role to help bring people together to move things forward. That's a good opportunity for me just to clarify, no taxpayer dollars are being spent in the preparation or filing of these suits. The organizations that are bringing them and their legal teams are working together to provide the resources. I've spoken with the governor a few times since this coalition commenced, and those are good conversations. I have, respect for the governor. We have strong disagreement on this issue for sure. The most recent time I was in a meeting with the governor was when we acclaimed Kamala Harris as the Democratic nominee, as New York's Democratic nominee. I'm a delegate, so that was on the electoral side. Obviously, that's a place where we are wholeheartedly and fully in agreement. On this one, we've made clear our disagreements and have a respectful dialogue about it, and the legal process is commencing today to implement the law as required. The lawsuits don't speak to the specific fee. They call for the implementation of congestion pricing as required by law, but they do not speak specifically to the tolling structure that had been agreed to. I mean, when you've got a coalition of litigation, they agree on what's in the filing for the purposes of the filing. So what people agree on here is that the law requires the implementation of congestion pricing.
So I'll take the first question. And so this is Troy Ledeen for Earth Justice. As for the novelty of both the CLCPA, the law, and the Green Amendment, the constitutional amendment that gives us a right to clean air, it's true that those are novel legal developments, right? These are recent things that our legislature and the people of New York have done. But I think this is an excellent backdrop on which to highlight just how powerful these protections can be. Because there might be edge cases in the future as these issues are litigated, but this specific issue, congestion pricing, there's no controversy over whether or not it's essential to reduce greenhouse gases, and there's no controversy over whether it's essential to get us clean air. In fact, in the Traffic Mobility Act that establishes congestion pricing, the legislature specifically calls out the air pollution that is happening with the lack of congestion pricing. So I don't think these are close questions in this case.
Hi, it's Andy Celli for the petitioners in City Club. No, the litigation is not going to slow anything down. It's going to speed things up. This is an Article 78 proceeding, which is an accelerated proceeding. The judge will set the schedule. There really are no facts that need to be developed. There's not going to be a trial with witnesses and all the things that go into making litigation go on forever. This is a legal issue. We're filing the papers today. The other side will have an opportunity to respond, and we'll have some more papers to file, but I would expect that we will be in front of a judge arguing this in September.
Look, there are a lot of reasons why congestion pricing needs to go into effect immediately. You know, first, it's been 15 years getting here. Had we done it 15 years ago, we would already have more accessible stations and more signal replacements and more on-time trains. And the longer we wait, the longer all of those things will happen. When crews that were planning to do a project demobilize, that project slows down. So there are many reasons why this needs to move forward promptly. Obviously, building the political will and the coalition is always challenging, and when something happens to disrupt it, of course, it means that the whole thing could fall apart. That's why we have long said that while the governor calls it a, quote, indefinite pause, we fear that it could in effect be the cancellation of congestion pricing, and that's why we're bringing these lawsuits. What various circumstances could cause that to happen? There are many. Could Donald Trump be one of them in some world? I pray not, for many, 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 many reasons. But the reason we're moving quickly, the reason the lawyers are getting into court, is that the law compels congestion pricing. The plan was for it to be in place on June 30th. We've already spent $500 million on that infrastructure, and we need to see it in place just as quickly as possible. Let me invite some of the advocates up if they want to address the issue of talking to legislators. I mean, the answer is yes. We actually did a call last week with that included many of the state legislators who were the champions of and supporters of congestion pricing to give them an update of what's going on. There's some conversation about the possibility of one or more amicus briefs from legislators clarifying things about what their intentions were. But I also think you can see that from what Andrew Celli said, the law is quite clear, so there's not as much need to interrogate the intentions. The intentions are clear, and the law still. Dialogue with them about the possibility of amicus briefs. The champions for congestion pricing in Albany, who worked with advocates, who got it passed, who stood up during the budget session and refused the governor's efforts to derail or open it up again, are very much a broader part of our coalition and fully in partnership with us here. You know, I don't. I have never bought the argument that this jeopardizes the chances of Democratic House candidates. Some of them, like my friend, Pat Ryan, are opponents of congestion pricing and make clear. Some of them, like Tom Suozzi, who I was out there knocking doors for, support congestion pricing, and he won a swing seat while being a quite visible supporter of congestion pricing. As for what has happened since Sunday, I will say the elevation of Kamala Harris to being our presumptive nominee dramatically outweighs in enthusiasm for the fall anything, I think, that could be related to congestion pricing. And, as a matter of politics, not of this lawsuit, I'm very optimistic about our chances this fall. And I will just say we absolutely can implement congestion pricing before November and have favorable results on Election Day. There's continued research on that. As I say, the two areas where there's continued research going on are around accessibility issues and the civil rights issues related to the cancellation of elevator and accessibility projects, a very live and real issue. And we're looking at the bondholder and credit issues. Because congestion pricing didn't go into effect, there aren't yet specific bonds that were issued against the anticipated revenues from congestion pricing. However, there is reason for concern already that the cancellation could affect the MTA's credit rating and raise its cost of capital, and that might wind up having other implications. Those could be on additional operating or service cuts. And if that happened, then lawsuits like the one on buses might move forward as well. And if that materially impacted existing bondholders, that could go forward, but we don't have any immediate plans for that suit at this time. That's right. We convened the Legal Strategy Coalition, right when the governor announced the decision. A lot of folks here were doing the hard organizing work of, raising New Yorkers' cry, pointing out why, this is a giant mistake. We just started reaching out to people and convened a legal working group that includes the lawyers who are here and a few others, that includes some of the advocacy organizations who are here, so that it would be possible to sign a joint defense agreement and do research that could be shared and strategic on what are the key claims, should they be in one lawsuit or several, who are the best plaintiffs to bring them, divvy up that work, match lawyers and plaintiffs. Now, of course, on each individual lawsuit, the plaintiffs and their lawyers are the right people to ask questions about the specifics of that suit, but we'll continue to convene partners to make sure we're acting as strategically as we possibly can. I'm sorry, say again, $1 billion on what? It's a great question. I think the public advocate spoke to this as well. This is not a tax. It's definitely not a tax on the middle class, and I think it's important to make clear that for folks who commute all over the city, but especially into Manhattan for work, are overwhelmingly people who rely on subways and buses. And those are the folks who will benefit from the investments that congestion pricing will bring. For working New Yorkers, congestion pricing will have enormous benefits to make their lives easier. Even drivers, bus riders, taxi drivers, delivery workers are losing 100 hours a year to congestion on the streets. So congestion pricing will actually strengthen the city's economy, save people time if they're in cars or on buses, and it dramatically improve commutes for working New Yorkers on subways and buses. So this is a pro-working class, pro-middle class policy. In addition, reducing driving modestly will help enormously at cleaning our air and reducing congestion. This has been done by cities all around the world, and it's an effective public policy for reducing traffic, for cleaning the air, and for investing in transit. And we believe deeply that it will be good for middle-class New Yorkers, for working-class New Yorkers, and for the city's economy as a whole. I have not had any conversations directly with the governor about it. I have talked with MTA officials about the challenges facing them for their capital plan. I went to the MTA board meeting a couple of weeks ago. And many of us have talked with the legislators as well, who declined to consider a payroll tax and declined to pass any sort of IOU because they don't know what other revenue source there would be that could provide the resources necessary to the MTA. Obviously, none of them would have the benefits of traffic reduction and air quality improvements. And we can't wait until the 2026 budget. The MTA needs to produce its revised capital plan in October. And without congestion pricing and clarity about its revenues, they've already made clear they're going to cut 23 elevator projects, including in that station where a woman died in cardiac arrest carrying the stroller up the stairs, and 22 more. And through other cancellations, there is not, no one has identified another source, and we can't possibly wait until next year's budget if we're going to move forward with the capital plan. Okay. Congestion pricing is the law of New York State as a result of the MTA Reform and Traffic Mobility Act of 2019. The Climate Leadership and Community Protection Act of 2019, as you heard, mandates decision-making that helps achieve emissions goals. What the lawsuits that are being filed today do is hold the state to the law. And I do think it's just important to understand that the core charge here is that the governor does not have the unilateral authority to cancel congestion pricing. It is the law, and that's why these lawsuits are being filed. Believe me, we wish we did not have to go into court to force the implementation of laws that were passed by the legislature, signed by the governor, and transparently require implementation.